On July 10, 2026, the All-Domain Anomaly Resolution Office quietly uploaded 40 new files to its PURSUE disclosure portal. The fourth batch, released under the mechanism Congress mandated in the FY 2024 NDAA. 14 documents, 19 videos, 4 audio recordings, 3 still images. No press conference, no explanatory briefing, just files, dropped onto a government website on a Friday afternoon. This is now the largest single tranche AARO has released, and it may be the most consequential because for the first time, cases originating from nuclear weapons facilities appear in the declassified record. What these 40 files contain, what they don't, and what AARO's silence about their analytical conclusions actually means. That's what we need to examine. Let's catalog what's actually here. Of the 14 documents, 7 originate from the Department of the Navy, 3 from the Department of Energy, a first for any PURSUE release, 2 from the Air Force, and 2 carry redacted source agencies. Case dates span from 2004 to 2023, with the heaviest cluster between 2019 and 2021. The 19 videos are predominantly infrared and electro-optical sensor captures, mostly from naval platforms. The 4 audio recordings include at least 2 pilot debriefs and what appears to be an operational communications intercept. The 3 images are high-resolution stills, one of which, catalogued as PR-104, has already generated significant discussion. Previous releases totaled roughly 50 files combined across 3 tranches. Release AARO 4 nearly doubles the accessible archive in a single drop. Start with the 2020 Navy Range Fowler clip. This infrared video, approximately 90 seconds long, captures an object transiting what military sources describe as an active weapons testing range. A range Fowler in naval terminology, meaning an unauthorized intrusion into restricted operational space. The object displays consistent thermal signature without visible propulsion exhaust. It maintains a trajectory that, according to accompanying documentation, triggered range safety protocols and halted a live-fire exercise. The document package includes the Range Safety Officer's incident report, which notes, and this language matters, no correlation with known traffic, civil or military. AARO provides no disposition, no analytical judgment. The file simply exists in the archive, unresolved. Document DOE UAP D090 is a 2019 pilot debrief, audio with partial transcript. The pilot, whose name and squadron are redacted, describes a visual and instrument encounter during a routine patrol. Key portions of the transcript reference an object that maintained relative position despite maneuvering and exhibited what the pilot calls no recognizable flight control surfaces. What's notable is the debrief format itself. This follows standard naval aviation mishap investigation protocols, suggesting the encounter was treated with the same institutional seriousness as a near mid-air collision. The interviewer's questions, partially audible, reference prior reporting from the same operating area. Roughly 40% of the transcript remains redacted under what appear to be sources and methods exemptions. Then there's PR-104, a high-resolution still image reportedly captured over the Yellow Sea, showing an object with a distinct 6-pointed geometry. The accompanying metadata indicates the image was taken from an airborne intelligence platform, though the specific system is redacted. The object does not conform to any known UAS silhouette in open-source military databases. Its symmetry has drawn comparisons to certain classified foreign drone prototypes discussed in congressional intelligence briefings, but no formal identification has been offered by AARO or any other agency. PR-104 matters less for what it shows than for what it represents, a case where imagery quality is high enough to potentially support identification, yet no identification has been provided. Either AARO doesn't know what it is, or it knows and won't say. Both answers carry implications. Now the nuclear facility cases, and this is where Release AARO 4 breaks genuinely new ground. 3 documents originate from the Department of Energy, and at least 2 are connected to the Pantex plant near Amarillo, Texas, the United States' primary nuclear weapons assembly and disassembly facility. These are the first DOE source documents in any PURSUE release. Prior tranches drew exclusively from DoD channels. The Pantex cases, dating from what appears to be 2021 and 2022, describe aerial incursions into restricted airspace above the facility. Sensor data accompanies at least one case file. The timing raises obvious questions. Congress has repeatedly pressed for disclosure of UAP activity near nuclear assets. Senator Kirsten Gillibrand specifically referenced nuclear facilities during the 2023 Senate Armed Services Subcommittee hearing. Former AARO Director Dr. Sean Kirkpatrick acknowledged in his 2024 testimony that correlations between UAP reporting and strategic assets were being examined. So why are these appearing now, in the 4th release, rather than the 1st? One possibility: DOE's classification authority is separate from DoD's, and interagency declassification review takes longer. Another: political pressure finally reached the threshold required to move DOE material through the pipeline. Here is the structural issue that transcends any individual case. Of the 19 videos in Release AARO 4, not one carries a published analytical judgment from AARO. No resolved as drone. No assessed as sensor artifact. No insufficient data. Nothing. This is not normal. AARO's own historical report, published in March 2024, established a framework for categorizing cases: resolved with high confidence, resolved with moderate confidence, or unresolved. That framework apparently does not apply to PURSUE releases, or if it does, the conclusions are being withheld. Legally, the NDAA provisions that created PURSUE mandate disclosure of records, not disclosure of analysis. Congress required AARO to release files. It did not, in the statutory text, require AARO to tell the public what those files mean. This creates an extraordinary situation. The government is releasing evidence while retaining judgment. The public gets raw data. The interpretation stays classified, or simply unperformed. Either way, AARO is technically compliant and substantively silent. Release AARO 4 changes the disclosure landscape in 3 concrete ways. First, DOE's entry into the PURSUE pipeline means the nuclear UAP nexus is no longer confined to witness testimony and legacy anecdotes. It now has a documentary footprint in the official disclosure record. Second, the volume and diversity of this release suggests the pipeline is accelerating, possibly under pressure from the UAP Disclosure Act provisions that continue to advance in modified form through Congress. Third, and most importantly, the absence of analytical conclusions across all 19 videos forces a legal and institutional question that Congress will eventually have to answer. Is disclosure without interpretation actually disclosure, or is it something else? A compliance strategy designed to satisfy the letter of the law while preserving the government's monopoly on meaning. The files are public now. The answers are not. That gap is where the next phase of this story lives.